Oh, just 1 second. Good afternoon, everybody. I just want to double check that you can all hear me. Could you just raise your hand, the people that I can see that are actively participating? Brilliant, thank you very much. Good afternoon, everyone. My name is Claire Milne. I'm the reporter appointed by Scottish ministers to carry out an examination of the Section 36 application for a pump storage hydro scheme, which is actually known as Red John, and that's located approximately 14 kilometres south of west of Inverness. So everyone on the screen that I expect to see at the moment is there. We do have a number of observers who are sitting behind, who aren't visually appearing on the screen, and will not be participating today, but just observing as they would as a member of the audience. Okay, just so I can double check who's taking part and also who is representing who, and who's leading the discussion. So for the applicant, which is Intelligent Land Investments, I have Douglas Armstrong QC. Can you just unmute yourself, Douglas, would you mind?
Is that it? Yeah, Ma'am, I appear on behalf of the applicant. My name, as you point out, is Douglas Armstrong. I'm a member of the Faculty of Advocates, and I'm instructed by Fraser Mitchell, partner in Shoesmiths, LLP.
Thank you. And for the Highland Council, Mr. Finlay?
Yes, may it please you, ma'am. James Finlay, Queen's Counsel, instructed by Karen Lyons from Highland Council.
Thank you. And we also have participating today is Fiona Henderson, who is a local resident. Fiona, can you just introduce yourself?
I am Fiona Henderson. I live within a couple of, well, less than a mile of the development.
Okay, thank you very much. We do have another interested party, Ms. Sandilands, who doesn't want to take part in the pre-examination meeting, but is reserving her right to perhaps take part in a future inquiry or hearing session. I don't have any other party that's indicated that they want to participate in any process or examination. So what I see today and who is involved today is the main participants, with potential of Ms. Sandilands joining us as well once we get further down the road. The case officer at the DPA is Fiona Manson. She's responsible for maintaining the file and any administrative arrangements. So you would have been in touch with Fiona at some point. She's currently working from home, but she is available to contact. And she's whom you should go to if you have any queries after this meeting. So before we get started, I just want to make sure that everybody can hear everybody else. We've had a little bit of a test run. We just want to make sure everything is working okay. So to avoid interrupting or speaking over other people, everyone will be muted, as you can see, until it's their turn to respond. And then you just unmute yourself when you want to speak. I think everybody knows how to do this now. There is a hands up feature, which you can use to signal to me if you want to speak, which would be really helpful. Or you could wave your hand as well. I'll look for that. But there is a separate hands up feature on the Zoom package. There may be periods of silence while participants find things or are looking for things, and that includes me. So just as you would be the same in person, it's a similar kind of operation. Can you limit the amount of background noise there is? Please switch off or mute any phones, just so that doesn't interrupt what's going on today. There is the potential for a breakout room facility, which we're not going to use today, but it's where the meeting could be paused and you could go and have a meeting with other people to discuss matters. But it might be something to think about if we go forward with a virtual inquiry process, how that might work in practice. Have your screen set to gallery view, ideally, so you can see everybody taking part. I think that's probably the best way to have this set up. And as far as I'm aware, Ewan has locked the room now so that no one else can join, even if they have an ID and a password. Okay, that's just basic instructions to get us started. Is that all clear? Nodding of heads, great, thank you. Okay, we'll now start the meeting. So the purpose of the pre-examination meeting is to discuss the procedural arrangements as set out in the agenda that is circulated. As is normal practice, I'm not going to allow any discussion on the merits of the case today, although I might need to touch upon particular topics just to understand the current position. I already have all the information that's been submitted to Highland Council and to the Energy Consents Unit of the Scottish Government. The purpose of any further examination is not to repeat what I already have, but to help me explain the differences that are currently not completely clear to me. As a note of this meeting will be produced and set out the procedural arrangements agreed. Obviously, in the current circumstances, our normal practice of live broadcasting of meetings is not possible. So we are actually recording this meeting, and as has happened last week when 2 further meetings happened in this way, they will be published on our website. So I'll just move on to the proceedings. The Electricity Act, dating from 1989, doesn't say very much about the procedures to be followed. In 2009, new appeal procedure rules were introduced and changed and modernised the way we deal with planning appeal cases and the applications called in by Scottish ministers. The changes are intended to ensure that the procedures adopted are proportionate and efficient, and that the process is transparent and fair. So the DPA has for some time been applying this approach to a wider range of casework, including Section 36 cases, and a lot of you will be familiar with that. We published a code of practice for handling inquiries under the Electricity Act, and I circulated a link to that in the agenda, which you would have all seen. Now, it is my intention to follow the code of practice with your agreement. As I outlined in my note for the meeting, the proposed procedures for this case are aimed at allowing all parties to have an opportunity to contribute towards submitting a TIMIUS report to Scottish ministers. The overall purpose, is to progress the case during the coronavirus restrictions. You'll be aware of the DPA guidance on this and our intentions to try and progress cases as far as possible. And that includes looking at alternative ways in which we might proceed by oral process. We'll come on to talk about that in a little while when we go through the proposed procedures. But I'd just like to check whether parties are agreeable and have no objection to following the code of practice that we would normally in these cases follow. Are there any objections? Okay, you're fine with that. Ms. Henderson? Okay, thank you very much. Right, just moving through the agenda, I'm going to try and stick to the agenda, but we might jump around a little bit in terms when we talk about timescales and the processes that might come forward. So I outlined in my agenda a note my provisional assessment of the main topics to be examined and those that may require further procedure. So first of all, I set out those matters that I consider might require a written submission. And I've based this on the representations made to the application and in my initial reading of the information that was been submitted and the EIA submitted information. So I'd now like to ask the applicant to update me regarding each of these topics. It may be that you'll be able to point me to a particular document where I can find more information on the matter. Once I've asked the applicant to respond, I'll then ask others to comment where relevant, if it's a particular issue that you want to make any comment on. So I've got a list of matters that I've indicated for further written submissions, A to K. And what I was going to do was ask the applicant to just, because in the majority of cases, it will be information that I'd be seeking from the applicant, to run through each of those and to explain to me if there is any more information I could be pointed to, and also what the circumstances are with each of that particular heading. Does that sound a reasonable way forward?
Yes, happy to progress on that basis. Thank you. Well, turning to paragraph 4.1, and first of all, in relation to further procedure, the applicant would be content to progress by way of written submissions in relation to A through to K. In relation to A, dealing with flood risk, I don't think there's anything further to update in relation to that. Ma'am, you've obviously got the information in the EIA, you've got the SEPA responses, and you've got the additional environmental information that's been provided. In relation to the B, the head pond, again, you have the information set out in the EIA. On that, the council, the applicant is happy to provide any additional information in relation to that, setting out the rationale of the need for the head pond, if required. In relation to 4.1c, again, the applicant can draw from the information provided in the EIA on these matters, and would propose to put that in the context of the net gain or the biological gain in relation to each one of these areas, the agricultural land, the woodland, and the habitat. And so again, the applicant would be happy to set that information out. In relation to D, again, there is the information contained within the EIA and updated information, and the applicant is happy to identify that and set that out in further written submissions. That also applies to E, F, and G, and in relation to H, cultural heritage, that there has been ongoing discussions with Mr. Sandilands in relation to his objection, and it's hopeful that that there can be an update in relation to that in due course. Also in relation to I and the conditions, again, it's hopeful that there'll be further discussions with the council in relation to the proposed conditions, and in relation to any legal agreement. In relation to K, there are ongoing discussions with SEE, and matters are moving forward in relation to a cooperation agreement.
Okay, thank you, Mr. Armstrong. Mr. Finlay, do you have anything you want to raise in relation to any of those points?
Ma'am, just in relation to I think we've had some comments from the applicant already on the conditions that we put forward. We'll turn those around and put forward our responses to those, so that we're happy to take that forward by written representation, and that would go for any legal agreement. I'm not up to speed on that as to whether one is proposed, but we can deal with both of those, and we'll make the running certainly on the next version of conditions at this stage.
Okay, thank you. Yeah, just to what I'll tend to do then, once I've heard from Mrs. Henderson as well, I'll decide how to take these matters forward, whether it might just to keep things clear, and in terms of timescales for everybody responding, I'll set out the matters in a further procedure note, so it's clear over what timescales we're looking at. Now, Ms. Henderson, would you like to come in at this point and raise any issues you have with these written submissions?
Yeah, there's a couple of places that you've mentioned additional information that's already been submitted. Sorry if I've missed it, but it'd be useful to be copied into some of that. And also, I think the main thing is the flood risk, that I've not been given access to any of that for confidentiality reasons. And obviously that's one of our strongest objections, as all we have is the EIA, which has the quote in it that basically says there's an acceptable number of deaths, and that would be our household. So it's quite important for us to understand how that has been concluded.
Okay, thank you. Yeah, that's the point you've raised in your submission. So my intention is to issue some further written submissions on this information to a range of parties to get to find out a little bit more about what's been happening. I'm not aware, everything that has been submitted has been put and is available to view, should be on our case management system, which is then published onto our website. There is this matter of a confidential report, and I think I'm right in thinking that I've read something somewhere that explains why that report has not been released. I wonder if the applicant could perhaps, Mr. Armstrong, could you maybe just explain a little bit more about that, just for my benefit just now?
Ma'am, I understand that there was a response to Ms. Henderson in relation to this matter, and it was set out in that response while certain information would not be provided because of confidentiality. Again, this is a matter that the applicant is happy to discuss with Ms. Henderson in greater detail to see the extent to which these matters can be resolved in the near future.
It's okay. Can I come back in on that?
Yes, you can. Yes.
I do understand the requirements for national security, and that there is a reason to not give information away that can impact on a national asset, especially an energy asset. So I don't have an issue with that. What I have an issue is the fact that there's no summary at all that's been provided to the public as to how the assessment's been done and how it's come to the conclusions that have come to. So I think there's a lot of information that could be released that isn't necessarily the breakdown of all the drawings and such like, that would show the weak points, for example, for a terror attack. I think there's a lot of information that, if I'd gone through freedom of information, probably would have had to be released. So I'd like that to be considered, that the whole report should be not released, that there should be parts of it that are made available, and if not, then at least a summary of that report, including methodologies that have been utilised. There's been a fair amount of correspondence myself where they've used the Reservoirs Act as the reasoning, and that is not the way that would control the effects from that. And my understanding, the Reservoirs Act isn't about the breach analysis. So I have 2 lines in an EIA isn't sufficient at this point, in my view.
Okay, thank you. Yeah, I think you've raised these points. I'm aware of where you're coming from on this. I wonder if actually a further written submission would be really useful on this, to get a little bit more information, so I can understand also the public release of further information. Mr. Armstrong, is there any potential for parts of the report to be released, or a summary of the methodology that was used?
Well, my understanding is that much of this is actually set out in the public domain, and also in the various correspondence. But if Ms. Henderson wants to set down specific items that she wants further information on, we can address that, hopefully without the need of going to take up time at an inquiry on it. And my client is keen to try and address these issues, if at all possible. Okay, there's the potential there. I'll come back to you, Ms. Henderson, on that. There's potential there for then to maybe get a little bit more detail as to what. Yeah, there seems to be a slight misunderstanding of, there might be some things out there that perhaps maybe isn't what you perhaps are expecting, Ms. Henderson. So can I just ask you to come in on that?
Yeah, just so from my perspective, the EIA has been the main source of information I've read. I mean, there's tomes worth of documents here. So I think if Douglas could point me exactly to where that information is, then I can have a review of it. However, to ask for what information I would like to see is kind of catch-22, because I'm asking for the content of a document I haven't seen. Okay. So actually I need to understand what's there to understand which bits. So it's a bit of a chicken and egg to ask it that way around. But I'm happy to review if you can point me exactly to where more information is. And as I say, the few lines that I've had read are very, very hand-wavy, and I would expect there to be a lot more technical content than what I've already seen.
Okay, what I'd like to do then, and I'll ask you to come in just now in a second, Mr. Armstrong, is for my benefit as well, is I'll issue a further written submission asking for where this information is contained, pointing us all to the location of where it is. I think it'd be very useful. And at that point, you can then come back and outline if there's areas where you feel that there needs to be further explanation or a summary provided, or if you're satisfied at that point with that information that's there. Mr. Armstrong, do you want to just come in at that point?
No, I was just going to offer to suggest that way forward. I think that seems the most appropriate way forward in the circumstances.
Okay, right, that's great, thank you. Is there any further comments anybody wants to make about further written submissions? We could talk about some timescales, but are you generally happy with the approach that I'm going to take to those matters that I've outlined in the note? Okay, now there will be an issue about timescales and how people are able to respond to the further written submissions. There are a number of items there. I might be able to combine a few of them, and it's obviously going to take me a bit of time, having just assessed the initial information that's come in on this application and getting to a little bit more of the detail and just to see what actual specific questions I want to ask. So I haven't got a specific timescales of when I might do that with other casework I have on at the moment, but I do intend to get onto it fairly soon. Now, obviously I'll give parties the opportunity to come back when I've asked for that information to be submitted, and there'll be opportunity for some correspondence backwards and forwards on various items if that's required. So what I'll do as a result of the note of this meeting, I will prepare a proposed timescale for further written submissions. But is there any concerns about the length of time that you are anticipating some of this to come forward? Just ask you, each of you, to just comment on that.
Ma'am, we're happy to work with the sort of normal timescales that are usually applied in relation to these matters.
Mr. Finlay?
Likewise.
And Ms. Henderson? Happy to just wait and see what comes from me, and then there'll be an opportunity for you to comment. There's no issues about the length of time that, or do you have other commitments is what I'm asking about.
I have no time issues, but there is something that, I don't know if this is the right time to raise it, but we need to be very careful about people being on site. And there have been cars around recently, and there's been people looking as if they could be doing work, and I don't know if it's related or not. But as a local resident, we don't want people here at the moment until it's really safe to do so. So I think that's my only point, is I don't want this brought too far forward and people trying to do things too early from a COVID perspective.
Yes, I fully understand. I think that's why, as further written submissions, I would be expecting that information to be already to hand and not expect people to be going out and doing further work at this stage. It's information that hopefully is already there and we can be pointed to and respond accordingly. We'll come on to site visits, which is something I do want to cover in a bit of detail later on, and how that's going to impact on the way that we go forward. So thank you for raising that. Right, I'll move us on now onto the next procedure which I'd set out, and that is the proposed holding of inquiry sessions on two matters. Now, the two matters that I highlighted in my note, and the first of these was really about the nature of the proposed development. Although this has come through under section 36 of the Electricity Act, I suppose it's just enabling me to understand, as a proposed hydro storage scheme, how that fits into the wider picture and the policy context that we have in Scotland and at a local level. And in some of the issues that have been raised in the representations also about electricity generating nature of the proposal, the demand for hydroelectric pump storage, the carbon calculator, if that is a relevant element to this scheme, the net benefits, and then in the normal way, looking at the relevant policies and guidance that's there to help me make my recommendation to the ministers. So that was the first. We'll just cover that initially. Are there any comments on having some kind of oral session on those matters, or in the current circumstances, or even in normal circumstances, would that be an issue that perhaps could be dealt with by written submissions? I'll ask each of you to comment. Mr. Armstrong, do you want to go first?
Yeah, I'm obliged, ma'am. The applicant is content to go by the procedure that you suggested in the annex of an inquiry session in relation to these matters, and thinks that it may be helpful for witnesses to set out these issues in greater detail and explain the background. And the applicant has, and we'll obviously come on to witnesses in due course, the applicant has 4 witnesses who could address all these matters. And was the council has got no issue in relation to these matters, and I think it is primarily Ms. Henderson who is taking issue in relation to a number of these matters. The applicant considers that this could best be dealt with by an inquiry session, and we're obviously going to come on to look at the issue of whether it could be a video conference inquiry or not. But again, the suggestion that the applicant has is that this would be ideally suited for a video conference inquiry.
Okay, thank you. Mr. Finley, do you want to come in on that, please?
Yes, ma'am. Our view is, firstly, Mr. Armstrong's right. None of this is likely to be contentious from Highland Council's viewpoint. Whilst it's a pump storage, the policy background for Section 36 applications and its relation to Highland Council's planning policies, energy policies and the like are Highland Council's well versed in. Whilst I'm not sure we have particular experience of the applicant's team, our experience generally is that there is limited, if any, dispute. So that our view is that this would be certainly capable of being dealt with by written submissions, or if you had further questions or Ms. Henderson wished to raise issues, then a hearing procedure would be far preferable to an inquiry procedure. It would enable, it'd be less daunting for Ms. Henderson. She may not be daunted by it at all, but maybe less daunting for her. And if it's not one where there's likely to be significant dispute between the council and the applicant in our submission, that would be a more efficacious way of dealing with it. And certainly in regard of this topic, we would have no difficulty dealing with that by way of a virtual session, particularly if it was in a hearing format. We do have more significant concerns about cross-examination, but given there's going to be limited, they're unlikely to apply to the first group of issues that you've outlined.
Okay, just before I ask Ms. Henderson to come in at that point, Mr. Armstrong, the suggestion of a hearing on this topic, is that something that you would support in this case, do you think?
Mum, that would be one way forward. It's obviously an issue I was going to address in relation to the options of video conference inquiry or not. I think in my limited experience, I have to say, of these matters, if we're going by a video discussion, it is, I think, easier to have a more formally structured process than having a hearing session where it works exceptionally well when people are sitting around a table and discussing matters, and the groups of experts and people who have a lot of objections can discuss in obviously a controlled way. Works very well when the people are present. I think it is harder to carry out a less structured format by way of video link. And that's why the preference would be that if there's going to be an oral session in relation to this issue, that it should be by way of inquiry session. Again, Mum, we're content to leave it up to you. You feel a hearing session it is attractive on this point, then we would accept that. Our preference would be an inquiry session, and I think on the practical side, if it's going to be by way of video link, it's more appropriate to have a structured way forward. We did also, in our initial response to this, indicate that we favoured going by way of written submissions, and again, we would be content to go by that process if you felt that was appropriate. But looking at the three possible ways forward, I think the inquiry session would be an attractive way forward to allow people to ask questions in relation to these important topics and issues, and also put in context the landscape and visual impact evidence in the context of the national policy in particular, and development plan and other policies.
Okay, thank you. Ms. Henderson, would you like to comment on this particular procedure going forward?
Sorry. So looking specifically at the energy policy side of things, I think if you look at my submission, my issue was the fact that there had been no carbon calculations submitted, and therefore it was impossible to make the case that there's a carbon benefit of the project, because there will be carbon loss in the project. However, to be able to do that assessment, because do these things as a day job, to do these assessments, normally it's done by looking at various energy strategies and energy markets and market scenarios, and normally 3 or 4 different market scenarios are looked at. It's quite a complex process. So to be able to present that and be able to respond to that, I think to do that in a face-to-face meeting is very difficult, and that there should be a written submission regarding that shows the carbon calculations that have been done and the energy transfer modelling that's been done. I mean, I would have thought the developer would have had to have done this, because to make the project financially viable, they need to understand how much electricity is going to be transferred and how much they're going to utilise the pump storage. So I would have expected this work to have already been done in electricity transfer terms, which is where the bulk of the carbon loss will be. So it's the fact that that information hasn't been provided. So in the first instance, I think a written submission would have been most appropriate.
Okay, right. There's a suggestion there. I think if we were going forward with any oral process, then there would be inquiry statements that would be submitted at the outset, leading on to documents that would then inform that inquiry process or hearing documents, and then recognitions from individual witnesses that would be put forward. There would be an opportunity, I think, if I understand the process correctly, that there would be for people to submit some written information that would then be used as the basis for any oral process going forward and taking part. But I understand what you're saying, that your suggestion, if I understand it correctly, is to have a further written submission process on that, to see what information comes in, and then to decide whether anything further is needed beyond that. You've raised carbon calculations as one particular aspect. I mean, the topic for that inquiry session would be quite broad. It'd be covering quite a lot of aspects in the wider policy context. And so it has quite a wide scope to cover lots of things. But if I understand it correctly, you, particularly about carbon calculations, you'd be keen to see something in writing first, and to see how that's been based on, and then to follow that up potentially with an oral process if that's required. Is that how I'm understanding it?
Yeah, I mean, to be honest, I agree with James that, you know, we know what energy policy is. We know that hydroelectric offers a great benefit. The question is that in this project, it hasn't been demonstrated if there is a benefit, how big that benefit is. And that was a question. So I think, to be honest, to spend lots of time going through all of those items, nobody's going to disagree with each other, because that's what the policy says. And it is national policy to have renewables, and I don't have an issue with that. The point I've got is simply, well, you're saying it meets all this policy stuff, but you haven't got the scientific evidence, which is what's required by a EIA process, is the scientific reasoning, not necessarily just the policy context. So I think the majority of my comments are really about how things have been presented in the EIA, and that, you know, this issue in particular has just been missed, the carbon benefit and the electricity trading side. Whereas I think the policy stuff, I don't think any of us are going to argue on that. So is it really worth wasting anyone's time and money to do that? Okay.
Yeah, I see where you're coming from. I think, yeah, there may be the potential here to focus in on particular, although there's a long list, there's a very broad list there of things that could be covered in that inquiry session. Actually, there's potential there to come in with, sorry, someone just put their hand up. I'll be back at that in a second. The potential to have focus in on particular issues. Okay, Mr. Findlay. Yeah, would you like to just come in at that point?
Yeah, just seeing if that hand up feature worked.
It did. Yes.
Yes, no, it's just to say that our view is that, and my particular experience is that hearing sessions can work very well. I conducted one with Mr. Jackman on an educational appeal some time ago, and now about 3 weeks ago, I think, by telephone link, which doesn't have the advantage of being able to see each other, and that worked perfectly well. So I think our experience differs from that of Mr. Armstrong, that really our view is that inquiry sessions are more difficult by way of virtual link. Hearing sessions would be easier, partially because one has an agenda and one can prepare much for them in advance. That said, I agree with what Ms. Henderson has said, that there's a lot here that's really not going to be an issue. And if the issues could be narrowed down to see whether there indeed are any contentious issues at the outset, so avoid the need for any form of hearing session, Highland Council would support that approach.
I'll ask you to come in again, Mr. Armstrong, just in a second, but just on that. So there's a potential there, perhaps, for me to issue something which starts to kind of tease out where areas are of contentious, or certainly not maybe clear understanding from all parts about where we are on certain topics, that we could then, you know, go either through a suggestion of a hearing session, Mr. Finlay, although Mr. Armstrong, you prefer an inquiry session. Could you come in on that point about maybe focusing on particular issues rather than covering the broad topics that I'd outlined originally?
Yes, ma'am. I mean, again, just for the benefit of Ms. Henderson, that there would obviously be documents lodged first of all, and the cases of the various parties would be set out, and the evidence wouldn't tend to be specifically directed to this proposal, rather than just looking at the general policy background. Much of this evidence is actually set out in the EIA, particularly in relation to the carbon calculator requirements and the net benefit in tackling climate change. But I accept that that is an issue that Ms. Henderson has focused in her submissions, in her objection, and it is a matter that we certainly have a witness who can give evidence on that, Ian Gillis, who will deal directly with that, and the net benefits of the proposal. I think it would be helpful to have that in the context, obviously, of the points 4.3a and B, and also in the context of policy. But again, I think this could be very much focused to dealing with Ms. Henderson's objection.
Okay, thank you. Right, I'd like to move us on to the next item, but if there's anything further anybody wants to raise at this point, I think I will go away and have a think about how we go forward with that one. There's a few possibilities there, and I want to have a think about the items that are in agreement and those that are still a bit of contentiousness there in terms of the understanding. And what I will do is I will put a proposal forward in my note of the meeting. I don't think we're necessarily reaching agreement here just now, but I think we've certainly moved in where we could maybe focus that particular session, and then how that goes forward, I'm not entirely sure at the moment, but potentially we could have a structured hearing, perhaps, on certain topics. So I will give that some more thought. Is there anything anybody wants to raise on that particular matter before we move on to item 2, which is the second inquiry session? Okay, right. We'll move on to the landscape and visual impacts, which is the main reason for objection from the Highland Council. Now, I've just put 3 general topics, but again, there may be areas in which we can focus in on this, and I want to give that some thought. And they're across the 3 stages of the development: the construction, the operation, and the remediation stages. Now, when I read the council's decision, I don't see the reasoning in that decision necessarily focusing just on the construction and remediation stages. It's particularly in relation to the construction and remediation stages. I suppose I want to know, if there still is concerns that exist around the operational stages as well, of the scheme while it's in place and operational, and if that's a matter that also needs to be explored as part of this inquiry session. Then we can have a talk about how that session might be ran, and how we take that into play. And I will then get an idea from each of you how the witnesses might be involved in that particular session also. So let's just start with the general concept of a session on landscape and visual matters, which I think we're all agreeable is a sensible way forward. And Mr. Armstrong, I'll ask you to comment first of all on what your thoughts are on a session and the nature and method of that session.
Well, Ma'am, as far as this session is concerned, there are three parties involved: the applicant, Highland Council, and Ms. Henderson. There is no suggestion that there are any point is taken with the assessment set out in the EIA in either of the objections. And that's not surprising because obviously the applicant's landscape team has worked closely with the councils, and there appears to be no criticism of the methodology, or indeed most of the conclusions set out in the EIA, certainly not in the report to committee or in the letter of objection. Accordingly, the issue of dispute is primarily focused on judgment and as to whether the effects set out in the EIA justify an objection. So I submit there's great scope for limiting the amount of time taken up with evidence. There's scope for statements of agreed matters, which could narrow this down considerably. And there could also be scope for, as well as having precognitions, having rebuttal precognitions, which could reduce this further. So, Ma'am, due to the limited number of parties involved and the nature of this, the applicant thinks that this could be dealt with by a video conference inquiry. This, I'd submit, is just the type of case that such an approach would be appropriate. There would likely only be one witness from the applicant in relation to this matter. And as I say, the issues, I think, could be clearly focused, and it would be suitable and appropriate to have an inquiry session by way of video in relation to this.
Okay, thank you very much. Mr. Finlay, any comments from your side?
Well, firstly, as I understand it, the focus of our objection is not primarily on operational matters, although there are some concerns from councillors there. Secondly, to pick up a point Mr. Armstrong raised, that we haven't identified at the moment any criticism of methodology or the EIA. I'm not suggesting there necessarily will be of methodology, but because this was a refusal against an officer's recommendation, Dr. Wimble, who's going to be our independent expert, may advise taking a different view. So we'll have to see how that goes, but there's no suggestion, certainly, I think Mr. Armstrong is right to this extent. There has been close liaison between council officers and his side, and it would be unlikely that there'd be significant methodological differences, or otherwise it will come down to matters of judgment in part. And we agree with him that there's a scope for agreed matters. As to the appropriate way forward, in our submission, this would be, because the effects are limited, this would be suitable for a hearing session. And I know that you have experience of a hearing session dealing with landscape and visual matters at Dell Wind Farm, where I was involved, which involved the impact of an access road, which is, whilst dissimilar in some ways, is similar in others. And so I say that because we differ slightly from Mr. Armstrong in the appropriateness of inquiry sessions by remote means, for the reasons which I've already alluded to. we think that a hearing session would be easier to run remotely and rather than an inquiry session, partially because it's a more structured discussion. The issues are identified in advance, the witness can prepare for those issues, and there is less need for interaction between advocate and witness. The issues that arise on cross-examination are that whilst one can prepare for cross-examination, but I'm not going to suggest that I'm going to be able to envisage all the lines that Mr. Armstrong might take or the way he might take them with my witness in advance, or deal with his witness, so that in our Highland Council's approach across a number of pre-inquiry meetings has been to raise significant concerns as to the use of virtual procedure for inquiry sessions. Although that said, I agree that of all the cases we're dealing with, the others, just so that you're aware, of Glen Sherrow, which is a much more significant case, and Clash Gower, these are much more limited issues in this case, and if there is a case that is capable of being dealt with by a virtual inquiry session, this might be it, but that's not to belie the concerns that I've just indicated. So if I can sum up, our preference would be for a hearing session. If it was to be a hearing session, we have no particular preference as to whether it's virtual or real. Real may be more appropriate, but if it is to be an inquiry session, our preference is for a person-to-person session for the reasons I've just indicated. But as I say, we consider that this would be an appropriate case for a hearing session on landscape and visual.
Okay, thank you. It's useful to know people's positions. I'll ask Ms. Henderson to comment as well. But just thinking about the practicalities of it for a hearing session, you're correct. I did run a hearing session on a quite focused issue on another case. And I'm just thinking about my experience of that and the potential to identify some of the issues in advance. A hearing session involves a lot of work from the reporter, actually, in terms of directing questions, asking parties to respond, and asking parties to take their turn in terms of responding to each of the questions. There's a possibility that the questions or the issues could be sent in advance as well, to give those participating a bit of a heads up in terms of where we might be going. So I will give that some thought also. Ms. Henderson, do you want to comment on the potential procedure for a landscape and visual session?
Well, I think kind of in my original objection letter, the concern for me is regarding construction as opposed to necessarily operational, because once the landscaping has established and the trees have established, then that will obviously help matters, and it's always going to be subjective. However, the point is, from my perspective, is making sure that that's dealt with. The big concern I have is the 5-year construction period, and it actually stands for the majority of the things that we talked under section 4.1, is have they been properly assessed, and therefore is the appropriate mitigation in there to an extent, and is it going to be conditioned to an extent to give confidence that the impact's going to be okay. So to some extent, I'm more bothered about how it's going to be conditioned to make sure things are done properly. I think you can argue all day on opinion on landscape and visual, unfortunately. And as a local resident, I'm going to not want it because it is next to us, but there's only so much you can do, and I do appreciate that. I'm quite happy with hearing process on that. The only one point I do have to add, though, is obviously because of the nature of it, if you're looking at photo montages and the such like, then to have them high quality, high resolution versions of things to be able to look at beforehand, if there's any new material, how that would be circulated and made available if we were doing things electronically.
Okay.
Because I think it's important we're all looking at good quality and not graininess on a shared screen.
Okay, that's a useful point, thank you. It is a little bit of a kind of, you know, the practical arrangements for this are still a little uncertain. We're doing very few of these virtual conferences, and this is going very well. But I'm trying to imagine being in an inquiry or hearing session and trying to run this in. I think the normal way that we do things probably won't translate particularly well into this kind of conference. It's almost like we have to change the way we think about how we run our business a little bit. Mr. Armstrong, do you want to come back on some of the points that were raised there?
If I could come back on a few, first of all, just in relation to Ms. Henderson's concern in relation to further documents and productions. Well, I would assume that the normal process is followed and they would be put on the DPEA website and people would have details and have that information. With regard to suitability for a video inquiry, I think Mr. Finlay has accepted that if there is going to be such a suitable application, this is really the one. And I'm taken heart by the guidance from the President of the Lands Tribunals, which has identified that where there are only a few parties involved and where the matters can be focused, particularly here, I would suggest by way of precognition and rebuttal precognition, and indeed, as Ma'am, you've suggested, perhaps setting out the areas of cross-examination. I think this is an ideal application for dealing with matters by way of a video inquiry session. It will be focused, and I would hope that it would not take up a great deal of time. If we have that, hopefully, statement of agreement, precognitions, rebuttal, and indeed an indication of the cross-examination. And as Ma'am, as you pointed out so far today, I think this this hearing has worked well. It is a structured hearing, and again, as I go back to an inquiry session, is a structured process, which I think would, in this case, work well under video.
Okay, thank you. Mr. Finlay, just on that point, I'm trying to really kind of tease out what the differences are between running as an inquiry and running as a hearing. The processes are different because you get involved in cross-examining different witnesses. If there's just a few people involved, do you think there is scope there realistically to run it as an inquiry session if we're only dealing with three main parties?
Well, I've been candid in the point that I made that Mr. Armstrong picked up on, that if there is scope, this is possibly the type of inquiry for which there would be scope. However, in our submission, a hearing session would have two major advantages. I referred to Dell, and you will have your own views on that. From Highland Council's viewpoint, whilst the outcome wasn't the one we wanted, the way the hearing session went was, we considered to be perfectly appropriate and teased out the issues that were concerned in that case. And the advantage of a structured hearing session over the structure provided by an inquiry session is that there is, whilst I accept there's more work for yourself, Ma'am, the setting out of an agenda in advance and even other parties giving questions in advance allows that to be dealt with in a way that allows preparation in advance of whatever session it's going to be much more effective and focused. The second concern we have about in cross-examination in part is that for landscape and visual sessions is that you are dealing with, unlike the policy session, what might call simple documents, you're dealing with visualizations and which tend to be not necessarily so amenable to being viewed on a screen effectively, and they're the type of session where a witness is on your shoulder, even if 1.5 meters away or 2 meters away, can point out things on documents to you whilst you're cross-examining the opposing witness that is simply going to be much more difficult to do in a virtual session. Now, we have a parallel system of communication running for this pre-inquiry meeting, which involves a Skype call, but because of bandwidths and etc., and being able to focus on screens, that is reduced to effectively a typed conversation. If there came a point that I wanted to take express instructions, no doubt I could ask you to do that and mute myself and then go on to the alternative system. That is, in our view, more, and I experience, more likely to happen in an inquiry session than a hearing session. So that's some more detail as to why Highland Council as a whole has taken this view across a number of inquiries and our practical experience of running them. Our preference would be for a hearing session. If so, our preference, then that could be dealt with virtually. If it to be an inquiry session, our preference would be for a in-person session.
Okay. Does anybody else want to comment on that at the moment? Mr. Armstrong, do you want to come back on that at all?
Well, Mum, just on the having documents up in front of the screen, there are facilities to have split screen with documents up on them if necessary. I don't really see that as an unsurmountable difficulty, particularly where all parties will have notice of what documents are going to be referred to and quite, details of the evidence on documents. So I don't think that's unsurmountable. I think this is, as I've said before, an ideal application for this process. It's clearly a process that's being operated in inquiries by video in England, and indeed the courts are operating with video hearings with cross-examination.
Okay, I'm going to move us on. We've talked about the kind of general concept of running an oral session on landscape visual matters, and I've taken board the comments that you've made, and I'll have a think about how that might go forward. What I'd like to talk to you now about is potential timescales. Now, there's been a bit of correspondence in the last day or so about the dates that I originally suggested, and they were really just a suggestion at this stage, just to kind of get some possible dates in the diary. Now, I understand whether we go by video conference or in person, we're talking about different dates, a shorter timescale for video conference and a longer timescale for an in-person oral process. That's how I envisage the current situation. And although we may see some movement with the coronavirus, we may see some lifting of restrictions in terms of movement. At the moment, the way it is in the Scottish Government is that we won't be carrying out any site visits at the moment until the guidance and Scottish Government guidance changes. But we may see a little bit of movement there. Now, that movement, I think I can see being very gradual, and the potential to have lots of people sat in a room somewhere, even if they're 2 meters apart, I think it's going to be extremely difficult to envisage in running some kind of inquiry or hearing session. So the first thing that we talked about was a video conference, and I kind of put initially a date of August. Now, the council has indicated that there are difficulties there with their witness, but also with council as well, to go out on site to see the site. Presumably that you haven't been able to see the site yet, and therein that needs to happen before any kind of oral process happens. Mr. Finlay, this point was raised by the council, I think it was yesterday.
Yes, no, neither myself nor our witness has been able to get on site. There are also, I think the 17th of August, the week of the 17th of August is school holiday week, so that my policy witness, if there needs to be a policy witness, may also have an issue. And on the 18th of August, I'm due in the inner house. Our suggestion would be the 24th of August, if that fits with you, which I know is a date that I think Mr. Armstrong's clients have put forward. That would hopefully allow sufficient opportunity if there is a lifting of the restrictions for Dr. Wimble and myself, certainly Dr. Wimble, to get on site to then prepare evidence sufficiently advanced to produce it for the 24th of August. Although that does, I first of all take Ms. Henderson's point about having people wandering around the area that are unwelcome at the moment, and our view that does rely on there being a lifting of the restrictions by July for that to happen. Our alternative was, just so if I put our stall out fully, is that we've identified, I think, 2 weeks, 26th of October and the 2nd of November, by which stage one might be more hopeful of an in-person inquiry. The Highland Council's had an inquiry session fixed for the 9th of November onwards, so that's the following week, for Glen Sherrow for 2 weeks, where parties are working in hope that there will be it will be possible to lawfully hold an inquiry at that stage in a particularly large, as I understand it, room in a hotel in Aviemore, or a complex in Aviemore. Actually, our August date, we would be ready for either a virtual, we would hope, if there's lifting of restrictions to allow site visits by July, to be ready for an in-person or a virtual session, whichever you decide, pursuant to our earlier discussions, by that second week in the 20th.
Week commencing the 24th
yes.
of August. Yeah. Can I just check with you, Mr. Finney? I didn't get the November dates there. So if we weren't able to have something in August, just remind me. So
the October dates were the 26th of October. The week beforehand is a half-term week, as I understand it, and then the week of the 2nd of November.
So week commencing 26th of October, and then the following week, which is week commencing the 2nd of November.
Yes, and perhaps I can just add, as you've asked me about dates, the week of the 31st of August, which is a date that I think Mr. Armstrong's agents may have suggested, the Highland Council have another inquiry starting that week, which is Clash Gower. And whilst there are a number of officers, we prefer not that week for that reason.
Okay, so the week before. Mm-hmm.
Yeah, and in any event, I'm meant to be in Stornoway in the Scottish Land Court that week, so it doesn't fit for me either. But for a number of reasons, that week is 24th of August is our preferred week in August.
Mm-hmm. Other than that, we're moving into end of October and start of November.
Yep.
Yeah. Mr. Armstrong, could you talk through some dates with me as well, please?
Yes, ma'am. First of all, can I just say that we're pleased that Highland Council have looked at this and are able to do the 24th of the week commencing the 24th of August. It's clearly my clients and their team's preference to have the earliest possible date, and that, as I think has already been set out in the letter yesterday, the 24th of August would be our team would be available for sessions in relation to landscape and visual matters the week commencing the 24th of August. I would have hoped that as far as the site visits, etc., the press release from the First Minister yesterday did indicate that further details are going to be known in relation to relaxations, I think this Thursday, and that there's an indication that there are going to be some relaxations coming into effect on the 28th of May. So I would have thought that there really is very few arguments against going for the 24th of August date if all parties are available for that. I'm conscious that 9 months have obviously passed since Highland Council decided to object, and thus cause there to be an inquiry here. I appreciate that the lockdown has affected all parties, Again, if the 24th of August is acceptable to Highland Council, then I think we should hopefully work towards having the sessions on the 24th of August. As I said, Ma'am, my clients, as I'm sure all parties are keen to progress matters. My clients now have a connection date of the 31st of October 2026. And if consent is granted, my clients are hopeful to commence work by the end of next year. And Ma'am, you will appreciate that MPF 3 identifies this class of development as needed and vital in meeting national targets, statutory climate change, and securing energy supplies. So again, the earliest possible date I submit in the circumstances is very desirable here. The other dates that would be available as a set out in the letter to the DPEA yesterday would be the week commencing the 31st. It could be the 31st or 1st or 2nd of September. Again, the 17th of August, the witnesses can be available for. And if matters were to progress to October or November, again, the 12th of October, the 26th of October week, and the 2nd of November, my client's team would make themselves available. But again, I would hope that would just be a last resort, and that the 24th of August would be the best week for everyone.
Thank you. Right, I understand where you are both coming from. Ms. Henderson, just to get an idea from you in terms of are there any issues with any timescales that are raised there?
I suppose the question is how long it's going to take. I'm on the Western Isles the last Tuesday, Wednesday of every month, and unfortunately managed to pick every last week of the month. So August could be challenging for me. The Tuesday, Wednesday, I could do the Monday. I could definitely do the Monday if it was virtual, because it doesn't matter where I am. So really, I suppose the question is going to be location and whether or not it's all going to be done in that one day. So 24th of August, as I say, would work, and potentially the Thursday and Friday of that week. I say that with a little bit of hesitance because at the moment we don't know how the flights and the ferry timetables are going to be reintroduced. So before lockdown, I could fly out in the morning and back in an evening, but it's unclear how soon those links are going to come back up again. So that's my only concern is, as I say, Tuesday, Wednesdays, the last week of the month, I'm not available. But I can do the Monday or so 24th, 27th, or 28th. The week of the 2nd of November definitely works for me. Obviously, I'm in Highland area, so the kids are on holiday until the 25th of October. So the 10th to the 25th of October is school holidays here. So the week of the 26th of October would work for me, but I think Highland Council were saying 2nd November.
You're okay. They get commenced on 26th of October, and you are okay the following week. Yeah,
2nd of November is better for me because the 26th of October I would have the issue with the Tuesday,
Wednesday. Yeah. Okay. Right. There's some complexity there, homing in on potential dates, and it all depends on where we go in terms of the type of procedure that goes forward. I think there's a lot of things for me to try and kind of get my head around and have a think about. And I'm not in a position maybe to make any decisions today, although I would have liked to have done that today, but I suspected this might happen and we would be left kind of thinking, right, what is the best thing to do in this case? I will put a proposal together and I will send that all to you and get your responses. I think that's probably the best thing to do in this current situation, because there's quite a few different scenarios there that could pan out. Does that sound a reasonable way forward? I've got everybody's positions. I understand where everybody's coming from. It's just a case of where might be the best direction to go in this particular case.
Yes.
Finley first, yeah.
Sorry, in terms of time estimate, which may which Ms. Henderson raised. It seems to us that particularly if if I can call it the first all policy session is going to be limited and focused, it may well be possible to deal with the matter within 2 days, and particularly if it's done by a hearing session, one could almost guarantee that. So it could be done on the Thursday and Friday of the week, either in August or in September. And secondly, whilst I can't miss the opportunity of accusing Mr. Armstrong of being Macaulay-like in his optimism as to the lockdown, I think he makes a sensible point that it may be worth waiting to hear the announcement and the route map on Thursday before reaching any final view as to the way forward, because if the signs are that things will be lifted, then we can understand. Although I think there have only been 5 months since Highland Council refused, not 9, or objected, we can understand the desire to get on with matters. We have no fixed preference between August and November or October. We're available for those dates, as I've indicated.
Okay. Mr. Armstrong?
Just to come back on dates, for the issue 1, the generating capacity, benefits planning and energy policy, well, I suppose that could be heard on the week of the 17th August. Again, I think that could potentially be dealt with in 1 day. For the landscape and visual impacts, that could be dealt with in the following week, the 24th of August, on the days that suit Ms. Henderson, potentially the Thursday or the Friday, or a Monday or Friday, whichever is preferable to Ms. Henderson. So I'd have thought over the weeks of the 17th August and 24th August, that there's 10 days, and all parties' availabilities can be addressed within that period of the 17th to the 7 weeks beginning 17th and 24th.
Just so I understand, I thought the council weren't able to make that earlier week.
There are problems with school holidays which affects the policy witness, and I'm unavailable on the Tuesday of that week. And Dr. Wimble considers the week of the 24th of August, given the likely lockdown and then the need to produce evidence, is a preferable week. But there would be 3 days that week, as I understood Ms. Henderson's submissions. That is the Monday, where one could potentially do policy, and the Thursday and Friday, where one could potentially do landscape and visual.
This is week commencing
24th of August.
Mm-hmm.
Ma'am, I was thinking that Mr. Finlay did indicate earlier on that he thought that the Highland Council probably have no points to make in relation to the first issue, and that's why I was mentioning that as a possibility.
Mr. Finlay, is that correct?
Well, I think it's unlikely there's going to be a dispute as to the policy situation. I can't tell what Mr. Armstrong witnesses are going to lead in terms of that. They're going to be limited. If there is to be a policy session, Highland Council would at least like to be a listening partner in it. It depends on if it is narrowed down to carbon calculating requirements and net benefit in tackling climate change, Highland Council are most unlikely to be involved. I'm told that if it was the week commencing the 17th of August, the latter part of that week, policy witness may be capable of being available, but if we could fit it into the week of the 24th, that would, to our mind, make better sense. But at the moment, we can't rule out being involved to a limited extent in the policy session until we see what issues are raised.
Yes, no, I understand. Yeah. There's a need to tease out really what that session could cover, as we touched on earlier, and I think that will then help hone down who really needs to be involved, to what extent they're involved, and then we can have a. But I've got the dates that people can make, and I've got a good understanding of how that, if we're going through to August, how that might work, and ideas of what method as well people prefer. So yes, if you could leave that with me now, and I can then work through that and see what I come up with. Ms. Henderson, you want to say something at that point?
So just something really general on the dates is that I've not got a team like everyone else. Therefore, partly there needs to be a time frame that we know we're going to get the written submissions in as early as possible, because obviously I've got to take the opportunity to review that while doing the day job. Although I appreciate the importance of getting it out the way, and Mr. Armstrong's wants to get on with it, also we need to make sure that there is the appropriate time for us to review the documents. So that's my only caveat. That's fine, but we need the documents June, July, not start of August.
For any oral session, there's a prescribed timescale within which documents should be provided by, and it's a staggered timescale. Now, the standard timescale is 8 weeks for inquiry statements, and then 4 weeks before the session starts for documents, and then 2 weeks before precognitions ordinarily. Mr. Armstrong is suggesting that there might be potential for rebuttal precognition, so it's building in time for that as well, which obviously we need to decide how we're going to take that forward and the detail of what that might cover. So, but I understand what you're saying, as long a timescale lead into that as we can. And obviously this is, I've got to take on board, myself included, a site inspection before any process can happen. And from, you know, from my professional point of view, I also need to have a view of the site before I'm involved in any oral process. I note the point you make about waiting to see what will happen with the kind of First Minister's kind of route map from here on, and I think it would be useful to hear what's said, if that's coming fairly soon, and then decide how things might pan out from thereafter, if there's enough detail on that. So I'll take that on board also. Okay, I've probably got as much out of that as I can at the moment. If everyone's agreeable, we'll move on to just discuss the next item that I have here, which is about agreed statements. And we've touched on some of this earlier, and I think there is the potential there for agreed statements on a range of matters. And this could include relevant policy documents, relevant development plan policies and supplementary guidance. Agreed conditions, which we've touched on, could be a matter for further written submissions as well, if the ministers are minded to grant consent, and any matters for any legal agreement. And I've added to that also the scope to agree any landscape and visual matters, which we touched on earlier as well. So there's potentially quite a bit there. And around policy matters, you know, there's potential there also to really hone that down into the key issues that might want to be covered at a session, so an oral session. A party's agreeable that kind of makes sense, that we try and whittle that down as much as we can. And in this particular case, there might be more scope to do more than perhaps normal in reaching some areas of agreement. Mr. Armstrong.
Yes, ma'am. I think it would be very desirable to do that. And I think there is scope here to agree a lot of matters, and particularly in relation to the background information policy and evidence. And kind of perhaps suggest that the applicants can start this off by perhaps preparing a draft agreed statement for other parties to then input into.
That would be really useful. That was going to be my next suggestion. Mr. Finley, does that sound a reasonable approach?
Yes, it does. I mean, technical point, but it may be more helpful to have two statements, one dealing with policy and one dealing with landscape and visual matters, because I have separate witnesses dealing with both. Mr. Heinsohn from the council is going to be dealing with policy matters, notwithstanding that he was involved in the officer's recommendation, but Dr. Wimble will be dealing with the landscape and visual matters. But yes, there should be scope, and I'm very happy for Mr. Armstrong to take the lead.
Yeah, Mr. Armstrong, I prefer if the applicant were to produce that as two statements. That would be helpful, just to separate those two matters out. I think just to aid understanding, and for also the witnesses involved further down the line, and it'll help us then to think about how the sessions themselves will finally kind of pan out in terms of how they go forward. Okay. So that's agreed statements. I'm going to move us on now just to touch on submission and deposit of documents, just to let you know where we are with deposit of documents at the moment. So any documents that anybody exchanges, the three main parties are here today. They should always copy in the other party and copy to the DPA case officer, which is Fiona Manson. So everybody's involved in any correspondence that's going backwards and forwards. Obviously, during the current period of restrictions with coronavirus, the council is not required to place any relevant material for the case on deposit in a public location. That may well change, but at the moment that's the case. So we are publishing all documents on our website. All documents should be up there, and anything that's submitted will be published accordingly. However, in the event that any documents can be placed on deposit at some point, we'll be asking the council for suggestions of where that can happen, and Fiona will be in touch about that at the appropriate time, Mr. Finley, so the council can respond. Now, for site inspections, I've already touched on this, and I think, yes, it all depends. If we're not looking at any oral sessions until later in the year, then it's not so much of an issue. The pressing issue is carrying out site inspections in this shorter timescale. If we're looking at an August or so process, I will keep an eye on that, and I will keep in touch with the parties to see how things are progressing. We will potentially be updating our guidance as well on that. So I would appreciate it if the parties could not, don't get in touch with me on a regular basis if we get another announcement and another announcement. The DPA is keeping a very close eye on our site inspection arrangements, and you can imagine it's inspecting all of our work. Most of our cases, if not all of our cases, have a site inspection process involved, and we're keeping a very close eye on it. So I will be in communication with you about that, and if there's any new guidance issued by the DPA, I'll ask Fiona to send that out to you so you can see how that's how we're responding to any current approach. Yes, Fiona, Mr. Henderson, sorry, couldn't come in.
You call me Fiona.
It's because I see the name Fiona. That's what it is.
Just on that, really kind of a basic thing, because work-wise we've got the exact same thing of having to do risk assessments to go out to sites and to send when to go out to sites. I'd really appreciate it if whoever's going out to site, whether or not we could be let know that they're going, and ideally have a copy of the risk assessment, just so we've got an understanding of what they're doing, because they are literally in our backyard, to just make sure they are staying safe and keeping local residents safe as well.
Yeah, that's very sensible, and that they've got some form of ID with them, so that if they are approached, that they're able to explain what it is they're doing and why they're there. Yes, yeah,
because there's we're getting a lot of people up here doing wonderful things like barbecues and camping.
Yes, yes, I'm sure.
Well, residents, I think would be the polite way to put it, when they're seeing cars just now. So I think to make sure that ideally the cars are identified and that people have identification on them is pretty important.
Okay, no, bear that in mind. Thank you. I think we're probably the next stage in terms of the DPA and how we go forward in terms of thinking about getting some of our reporters out back on site is that risk assessment, and also because basically up to now we've just pulled everybody back and helped everybody inside. Nobody is going out on site at the moment, but this gradual process of going back out will need some careful thought. And yes, people identifying themselves and being aware of how they are approaching the situation is going to be very important. Okay, if I'm going out on site, you would be notified of that. You wouldn't be told exactly when I would be going out. The difficulty with that is, as is normal practice, the reporter, if I'm going unaccompanied, which I would be initially going unaccompanied, I don't want to be approached by anybody who knows that I'm around. If they know the reporter's there, they might be tempted to come and speak to me. So that's a little bit of a difficulty. But if I am going on site, and I will try to do that when the restrictions are lifted, then if I am approached, I will explain the purpose of my being there, and that would be that. And then I would carry out my site inspection. Yes. The difficulty is an accompanied site inspection further down the line. It's something we can just touch on, because normally what would happen is, as after the inquiry finishes, we'd normally have an accompanied site inspection and be able to go out and have a look at the site together, and any points that parties want to make can be done on site. Is that just, I'm putting this out there just now as a question for all of you, do you think that it's necessary that I would need an accompanied site inspection for this particular case, or do you think that I could see everything with the information, visualizations, and as a result of having been through an oral process on landscape and visual matters, which is primarily what I would be looking at on site, that I could do something unaccompanied after the inquiry finishes. So I'll ask Mr. Finlay first, from the council's point of view, do you think that's a reasonable way forward, or are there issues with that?
I suggest it is a reasonable way forward, but can I add one caveat that maybe Dr. Wimble will have a view, but obviously it's not going to be set in stone. But as a starting position, that seems to be to be sensible.
Mr. Armstrong, do you have any comments on that?
Ma'am, no, again, I think that's a reasonable way forward. And again, I'm sure parties can agree that if there's specific places or sites that they would want you to see, I mean, I'm sure that can be agreed. And again, I'm sure we've all got past experience of, putting that on an ordnance survey map where the parties would like you to go and stand or look. So I'm sure here there is no requirement for an accompanied site visit. Particularly again with the number of parties involved and the areas in dispute, I'm sure that can be agreed between the parties where they would like you to go and look.
So it's not going to be necessary for me to actually get onto the site. There's 11 viewpoints, and it's just useful to know the receptors, that the majority of those are residential, recreational routes and road users in the main. Are there any viewpoints that are actually on the site, or are they all from remote locations from the site?
Just so you're aware, you actually drive through Head Pond. The current road drives straight through the pond. So you are on site, and the rest of the site, or the majority of it's forestry. Okay, right. So there's one forest track, which isn't necessarily a viewpoint. You could easily walk down that. It's public access track, and it's also, there's the track which is part of the Seven Lochs cycle route, that gives you access through parts of the site, and everywhere else I think is publicly accessible, or you're pretty much on a road, or there's a track at the back of our houses which I don't think has been put in as a viewpoint, but you'll see it, you can drive down it, you can have a look. Yeah, okay, so it sounds like I could get around very easily without any restrictions, and but what would be useful to know, if there's beyond the 11 viewpoints, and once we get a bit closer to this, I can get an idea if there's other locations that parties want me to have a look at while I'm out on the site. Okay, that's good. That sounds a reasonable way forward. Just moving on to final couple of items. The video, just to touch on the video conferencing. So we're using Zoom at the moment, and we will continue to use Zoom and for the time being, but I'm not sure if Scottish Government are going to stick with Zoom as the thing that we will go forward with. So it may be that there'll be another system in place next time we talk. But you and others in the IT team will keep you up to speed on that in terms of whether that changes. I don't have anything further that I want to raise with everyone. I think there's quite a lot for me to try to go away and digest there. I'm going to ask each of you at the moment if there's anything further that you want to raise with me. Mr. Armstrong, first of all, is there anything further from any other business you want to raise?
There was just one point in relation to the annex to the agenda, and that was in relation to the topics or the issues that you indicate no further procedure on. And yes. Again, the applicant is content with that under the one proviso that obviously in relation to forestry and also socio-economic, they will have an input in relation to the net benefit in tackling climate change and the net benefits of the proposals in relation to the issue, which is either going to be heard by inquiry or hearing session or potentially written submissions. So whilst we're content for the procedure in relation to these topics, the no further procedure, the evidence that is in the EIA in relation to these matters will be relevant in relation to net benefits, but that's the only issue I would have on that.
Yeah, I mean, the annex is just a kind of overview, really, but I understand that there's a bit of crossover between some of these topics. So it's just indicative at this stage, but I appreciate these matters will come in probably in some form, and some elements of them will come into the sessions that we'll cover. Okay. Mr. Finlay, anything further to add?
No, ma'am. Thank you.
And Ms. Henderson, anything further from your side?
I'm going to ask a question which is just going to show my naivety. I previously, obviously, I put in my objection letter and we received a response from the applicant on that. I never responded to that letter. There was quite a few things in there that I disagreed with. However, I'm wondering whether or not it's worth me highlighting the odd thing that I might have agreed with from a point of view of Douglas putting together the list of agreed matters.
Okay, just track back a little bit. The letter that you came in, the response from the applicant, now remind me, is that, what date is that, so I can get my hands on that?
Consultant. The 20th of this, oh, wait a minute, no, wrong one.
I might have it, I'm just going to check.
Might be. I shall have to dig it out. I'm sorry, it's in my.
That's okay. What I can do is perhaps ask you to, unless Mr. Armstrong can lay his hands on the document.
I think the other little point about that document was there's a number of things in there that I've probably moved on since then. So Mr. Armstrong, I don't know whether it's worth almost a update from yourself on any of the comments as well, because I know that there was a couple of things in there. Yeah, I've just found it. It was the 27th of February 2019.
27th of February, not 2019.
Yes.
Okay, I'll have to locate that.
I can forward it.
It'll be in our system. But yeah. Mr. Armstrong, do you want to just respond on that particular?
Just to clarify, is that the document that runs to nine pages?
Yeah, 9-10 pages. It's ACOM.
Yes, yeah, I've got that in front of me. It would be helpful, I think, if Ms. Anderson, if you're happy to come back and or we can discuss which areas you're in agreement with now, which areas matters have moved on since then. I think that would be useful, and it might again save some time and feed into hopefully the joint agreed position of parties.
Yeah, I mean, for example, it would be beneficial to find out where you are with regarding the carbon calculator, because the response I got was there isn't peat on the ground.
Well, I think the response goes to set out the policy position and the requirements in relation to that, but that's a matter that can be discussed, I'm sure.
So yeah, I think you know, that one, for example, is one. Definitely not, but there's probably a few other things. So I can provide a little bit of response back if that's of use. I mean, to be honest, my upset in the whole process is that nobody actually just came to speak to me about it. We could have resolved a lot of it already, so I'm happy to speak to you.
Well, I'm certainly happy for some liaison to go on between yourself and the applicant, copying in the other parties where you feel that's required, so that we can keep up to speed, and I can keep up to speed of where some common ground might be found between yourselves. So yes, if you want to initiate, I think that you're going to initiate that, Ms. Henderson, and make sure that the DPA are copied in, and also the council are aware of what's going on. I think that will help move things on in terms of where we go with some of the sessions as well, and my understanding of where things are at.
Good.
Good, great. I'll have a read of that document as well on the 27th of February, which I've probably not got in front of me just yet. Finally, I think we've reached the end of the meeting, and thank you very much for that. That was just looking how long we were on that, an hour and 40 minutes nearly. So just gives you an idea of how long things take to kind of talk through. Like I said, I will produce a note of the meeting, but I'm going to hold off doing that until I've got an idea of where things are going in terms of movements and restrictions going in terms of you know, how we look at August for a potential date. I will put a proposal down and I'll get your comments on that. I think at some point I'm going to have to try and hone this down in terms of the topics that are going to be covered and the procedure that we're going to go forward with. It's an unusual situation because normally, you know, I'm almost asking people to waive their rights in terms of the normal way that we would do our process and oral process and inquiries. But I appreciate you can understand the current situation, and also, and I've listened to the circumstances in which you've described and the difficulties also with running sessions in a particular type of way. I hope you felt you've been able to contribute today, and I just want to thank you for your participation, and I hope that everybody behind the scenes also was able to hear what was going on and follow the process. So thank you very much. If there's nothing further, I will end the meeting. Is everybody happy to finish up at this point?
Thank you.
Okay, thank you very much and goodbye. Thank you.